Okay, so we're going to discuss medical, legal, and ethical issues, Chapter 3 in your textbook. The national education standards tell us from the preparatory level that EMRs should have simple knowledge of the system, of well-being, and of medical legal issues. Some specific issues, we need to understand consent and refusal, confidentiality, advanced directives, some criminal and civil actions that are called torts. The civil actions can be called torts. Talking about evidence narration and what your responsibilities are under the law on certain issues. We will also talk about some mandatory reporting issues, ethical principles versus moral obligation, and end of life issues as well. So, because laws differ from one place to another, and you need to learn the specific laws of your jurisdiction, we are also going to spend a little bit of time talking about some Mexico-specific stuff that won't be in your textbook. But basically, if you follow these sort of three guidelines when you're providing care to patients, you should be okay for the most part. So first is we don't want to do harm to anybody. People are going to see us, they've already been harmed or they're injured or they're sick. We don't want to make them worse. We want to act always in good faith, and we always want to act on what's best for the patient. If, when you're providing care and making decisions, you keep in mind that the patient's best interest comes first, then you, again, should be doing okay. And then provide proper care that is consistent and be compassionate to the people you're dealing with, whether they're family members or patients, bystanders. And if you keep your composure, maintain your compassion, most people are going to be happy with what you're doing. So you have what's called a duty to act, potentially. And what that means is that you have an obligation to respond to a call. So if you are a volunteer, some volunteer departments put out a duty roster where they're saying so-and-so is on to respond to calls from this time to this time. That may give you a duty to act. It just sort of depends on how that is worded. If you're paid, on the other hand, as soon as you clock in, you have a duty to act. So that means if a call comes in, you've got to go, and you've got to provide care the best way that you know how, and with your training and what to do. If you don't follow your duty to act, if you, let's say you're getting off shift in 10 minutes or something, and you say, nope, I'm not going to go because it's far away, and they can wait 10 minutes, you violated your duty to act, and you've exposed yourself and your employer to some pretty significant legal action, potentially. So bottom line, if you're on the clock, the pager goes off, you're going. Standard of care is what is expected of you, how to act, how to provide medical care, the type of medical care you provide. So when standard of care is being judged, they look at, did you do your best for the patient? And they're also going to look at what another EMR with the same level of training and the same amount of experience would do in a similar situation. So if you're a brand new EMR, they are not going to expect you to do the same thing as somebody who's been on the street for 10 years. That person has a greater amount of experience than you do, and the law and the standard of care recognizes that difference. So there will be some variation even within a level of licensure. Scope of care or scope of practice, it's defined by the DOT. There are national DOT education standards. That's what we reference at the beginning of many of these chapters. It is also defined by the New Mexico state scope of practice, and then it's also limited or can be limited by your protocols, which are written or standing orders. Protocols and standing orders are effectively the same thing. And then it can be limited by your online medical control or your online medical. They can say, I don't really want you to do that, but they'd have to have a pretty good reason to tell you not to do something that's already in your scope. So ethical responsibilities. When we talk about ethics, we mean acting in a way that conforms to the accepted standards, the accepted standards of your profession. So what do we mean by that? Well, we mean you need to stay up to date. You need to keep yourself educated on what the latest is in your field. You need to critically look at your performance and see if your performance meets the standard. Are you may find at some point that you're not performing well at a certain skill. Well, that means that your ethical and professional obligation is to practice and to figure out why you're not doing well on that skill and improve. Response times. Are you taking too long to get in the truck? You should look at these things. Continuing education, we've talked about. You got to stay on top of this. EMS changes very rapidly. It's a young profession, so it changes very rapidly. And it's incumbent on you to stay on top of those changes, and you do that by taking CE classes. And then participating in QI, quality improvement. This may be as simple as writing good reports so that they're turned in and your QA or QI officer can review them. It also means that if somebody gives you some advice on how you could improve your report writing or your care, that you listen to them and take their advice to heart and look at it and see if there is a place that you can improve. So you should do so. And you need to be honest. This is overarching over all of these things. If you make a mistake, and the likelihood is that you are going to make a mistake in care at some point, you should document it and say, this is what happened, and this is how I noticed it, and this is how I corrected it. That likely is not going to get you in trouble. However, if you don't document it, if something goes wrong or it doesn't work exactly the way you should, and you don't document that fact, and instead you try and pretend it never happened and cover it up, you're going to get in trouble about that one. And quite likely the state may start looking at your license because that would qualify as sort of unprofessional conduct, that they could look at that as. And don't change a report. Now, if you make a mistake, you write something down incorrectly, yeah, of course you can change that, but don't, after the fact, go back and change a report to reflect something different than what actually happened. Again, the cover-up is often worse than the, quote, crime, so to speak. So cover-up is worse than the mistake. Consent. Our patients have to give us permission to take care of them, and there are a number of ways that we can get consent. Expressed consent is the patient tells us that they are willing to accept treatment. Now, they can do it non-verbally, they can nod, it can be accepted. You say, hi, I'm from the ambulance and I'm here to help, and they say, oh good, and here's what's my problem. That's understood that they are consenting to your treatment. Now, if it's a little bit sketchy and you're not sure if they're consenting or not, you may want to actually ask them, is it okay if I check you out? Sometimes they say no. They have the right to say no, except in some very limited circumstances, which we'll talk about here in a little bit. Also, you need to know that the patient has to be of legal age to make their own medical decisions. Legal age in New Mexico is 18. They can be what's called an emancipated minor if they're younger than that, but we'll talk about that again here in a little bit when we get into the New Mexico specific stuff. They also have to be able to, in your judgment, make a rational decision. Now, it's not enough for you to say, well, I disagree with their decision, therefore it isn't rational. There has to be some medical or trauma reason or psychological reason where you can say this person was not making a rational decision when they decided to refuse care. But again, we'll talk about New Mexico specific towards the end of this presentation. And then there is what's called implied consent. This is for somebody who is unconscious or perhaps has an altered level of consciousness, and they're not able to refuse or accept emergency care. So the law believes that everybody would want care if they were able to give consent. So if they're unconscious, the law says go ahead and treat them because that's what they would want if they were awake and able to say yes or no to treatment. Therefore, unconscious people will get treated under implied consent. Minors, somebody under the age of 18, they're not legally able to speak for themselves. So there can be some sticky situations legally when we're dealing with minors. When we're talking about minors, you can provide emergency life-saving and stabilizing treatment to a minor without their parent or guardian present. Anything beyond that, if you need to provide more than emergency life-saving measures to a minor patient whose parents are not or guardian is not present, you can't do that. So you may bring somebody to the hospital and they may get stabilized, but if anything further needs to happen, their parents or their guardian needs to be contacted. Again, if there is a minor whose parents or guardian are not around, worth talking about implied consent at that point, and the law assumes that their parents or guardian would want them to get treatment. Now, the flip side of that coin is that minors cannot refuse treatment. They cannot refuse transport. So if there is a minor who says, I'm fine, I don't want to go to the hospital, but there's no parent around or there's no guardian around, they have to go to the hospital. And they can not get any care, perhaps, because there may be no life-saving care required, but they still have to go to the hospital because they cannot legally sign the paper that absolves them of having to go to the hospital. They can't sign the refusal paperwork. Mentally ill. If there is a mentally ill person who is a threat to themselves or others, if they are homicidal or suicidal, they're going to the hospital. They get medical care. The assumption is that that's not normal for them, and it's not normal for people to want to kill other people, and therefore they need treatment, and we're going to provide it. If you are at all unsure about this, call law enforcement and get your medical director or medical control on the phone and discuss it with them and say, Doc, here's what I've got. What do you think? In New Mexico, the EMS Transport Act, which we'll discuss further, is what allows us to transport somebody against their will. And we're going to talk about that again at the end when we get into New Mexico specific stuff. So, refusals. Refusals are often said to be the most common source of lawsuits in EMS. So, somebody says, I don't want to go to the hospital, you leave them at home, and they come back and say, well, he didn't take me or she didn't take me to the hospital, I wanted to go. So that may come back to bite you. It's important then to mitigate the risk yourself that you carefully document refusals that you go on. And don't push patients into refusing treatment or transport. If they say they want to go to the hospital, bring them. It's so much easier to bring them. On the other hand, if they say, I don't want to go, they don't have to go. You can explain to them what may happen if they refuse care. You can tell them the treatment you want to provide for them. You can tell them why you think they need that treatment. You can tell them what you think is going to happen if they don't get the treatment. I have gone so far as to say to patients, I'm concerned that if you refuse this treatment, you may die before the end of the night. Do you understand that? And if they say yes, they're welcome to refuse treatment. New Mexico law gives you the right to die at home if that's what you choose to do. But you can also say, hey, listen, your family wants you to go. I think you're having a heart attack. I understand you don't want to go in the ambulance. What if you go with your family in their car? So again, do what's in the patient's best interest. And if it's in the patient's best interest to go to the hospital and they refuse to go with you in the ambulance, well, maybe you offer to follow them to the hospital and say, we'll be right behind you. If anything happens on the way, pull over and we'll take care of it from there. Patient refusals need to be documented very, very, very carefully. As I said earlier, they are among the most commonly litigated calls in EMS. So document everything. In the example I used earlier, when I told a patient they may die if they don't get the care that I'm recommending, I would literally write that in the report, and I would have the patient sign it, and I would have a family member sign it, so that everybody was very clear of as to what I had said, and that the patient had said they understood it, and that they still elected to refuse treatment. It's totally within their right to refuse treatment. They just need to understand the potential risks of them doing so. Advanced directives. So this is a document. There could be a living will or a durable power of attorney, or a DNR is probably the most common. It tells what a person wants to have happen if they are unable to make their own medical decisions. So a living will may appoint somebody else, or a durable power of attorney would appoint somebody else and say, hey, if I can't make my own decisions, this person is in charge. A living will says, here's what I want to have happen to me if I ever get in a position when I can't make decisions for themselves. Some patients may have both durable power of attorneys and a living wills, and their power of attorney, if they're on scene, may say, here's their living will, here's my power of attorney, and here's what they want. And those decisions are binding. And then a DNR. DNR is a do not resuscitate order, and basically what this is it's saying, if my heart stops or if I stop breathing, don't try and resuscitate me. Don't do CPR, don't put airways, let me go. Typically, DNRs are acquired by people who have known um, terminal diseases. And they're saying, I know I have terminal cancer, I know I have terminal heart disease, or whatever the case may be. And if I die from that heart disease, leave me alone. I don't want tubes, I don't want airways, I don't want medications, I don't want CPR. This doesn't mean, DNR does not mean do not provide care. So if you have somebody who has terminal cancer and you show up and they're having an asthma attack, that's totally unrelated to their cancer, you can and you should and you must treat their asthma, because that's not what the DNR is for, nor is giving them an asthma treatment resuscitation. So it's important to understand that a do not resuscitate order is not a do not treat order. So they should still get the appropriate treatment as long as it's not resuscitative measures. If you can't determine the validity of a DNR or an advance directive of some type, always you should err on providing care. If you see a DNR, confirm it belongs to the patient. If they have tried to destroy it, that invalidates the DNR. So if they've torn up or eaten or burned or whatever their DNR, and you walk in and the family says, well, they had a DNR, see, it's here and it's all burnt up, that DNR is no longer valid and you need to provide care. Okay, so next we're going to talk about abandonment. Abandonment is when you start care on a patient and you stop before another trained provider takes over from you. So the trained provider who is going to take over has to be at least at the same level of care as you, or higher. So if you're an EMR, you can't just transfer care over to somebody on the street corner. You have to transfer it over to another EMR or an EMT or an AEMT or a medic or somebody who has the same or higher level of training as you. Once you've started, you can't stop unless somebody who is equally or higher trained than you takes over. If you do, you've committed abandonment. People who are dead at the scene, Overarching rule here is if there is any indication that they are not dead, you should start care. And then you want to look for what are called obvious signs of death, things like decapitation, where their head is separated from their body. That's totally incompatible with life. Rigor mortis, which is a stiffness, a muscle rigidity that comes on after death, that is irreversible and is not going to change no matter what care you provide. Tissue decomposition, clearly if their body has started to break down and is rotting, they're beyond our ability to do anything for. Same thing with dependent lividity. Dependent lividity is what happens when blood flows to the lowest place in the body because it's just settling with gravity. So if somebody is lying on their back in bed, you may see a line, and the back of their body is going to be potentially purple, reddish, and there'll be blood pooling back there. Again, incompatible with life, nothing we can do about it. So if those signs of death, of obvious death, are present, there's nothing we can do for them. So we don't start treatment. But you've also got to look at your local department's protocol to figure out what exactly is your direction. What are you supposed to do when you find somebody on scene who is dead? Do you call state police, local police, OMI? That's Office of the Medical Investigator. What exactly do you do? That's going to vary based on your local protocols. Negligence is something that people are concerned about a lot, but I think their concern is too much. People are very concerned about it, but the reality of it is negligence is a pretty steep bar for somebody to meet. So basically, for somebody to prove negligence, they must show these four things. Number one, you had a duty to act. We already talked about what that means. Number two is you breached your duty to act. So you should have gone, but you didn't. Number three is there were injuries caused by your actions or your inaction. So you did something that caused harm, or you didn't do something and the harm was worse. And number three is there has to be what's called proximate cause. That means that the harm that was caused can be traced back to what you did, whether it was an action or an inaction on your part. The cause of the harm can directly be traced to what you did or did not do. Without those four things, negligence can't be proven. So it's a pretty high standard for somebody to meet. Confidentiality, there's a law called HIPAA, HIPPA, and Health Insurance Privacy and Portability Act, if I remember right, is what it stands for. The part of HIPAA that most impacts us is what's called protected health information. And that is information that identifies the patient, can only be shared with people, not just other medical personnel, but people who are involved in the care, in the ongoing care of that patient. So if you bring somebody into the hospital, you can't go wandering around the hospital and tell everybody about them. But if somebody's going to be involved in their care, yes, you can talk to them about them. Same thing with somebody who's turned over, you're turning over care to. And same thing for training. So if you need to discuss a call with your supervisor, your training officer, and say, here's what happened, what do you think I should do? You can discuss the call, but make sure it's not identifiable to an individual. That's sort of the golden rule. The individual shouldn't be identifiable unless there is a good reason why somebody needs to know the identity of that person. Sometimes, if somebody has a signed release or something of the sort, you can release confidential information. The biggest reason is that they're involved in the care. Okay, so if they're involved in care, they clearly need to know about the patient. And here we see HIPAA. I actually had it wrong. It's the Health Insurance Portability and Accountability Act. It's HIPAA. And it is a law that strengthens protection for health information and safeguards confidentiality. And violations of HIPAA can be punished by something like 6 months in jail and a $50,000 fine for every occurrence. So you don't even want to go down that road. Just don't even get close to violating HIPAA. Good Samaritan laws, what these say is that if you are a citizen, so not a medical provider, but if you are a citizen and you uh, help somebody who is in an accident and you do so in good faith and you don't do any advanced care, you are protected from that person suing you for damages. The idea was lawmakers wanted people to stop and help when they see somebody on the side of the road who's been injured, so they devised a way to protect people who stop to help. Now, those protections don't really apply to you as an EMS professional. You are not considered a Good Samaritan. A Good Samaritan is a lay person. So in New Mexico, the Good Samaritan law applies to lay people, and you may have an argument that it applies to you if you're off duty and out of your district and you stop in an accident to render aid. But basically, don't do anything beyond your scope, and as I mentioned at the beginning, our overarching theme here is do what's best for the patient, and you likely won't come across a point where you're going to be worried about Good Samaritan laws. We're going to talk about some regulations in New Mexico. Is another presentation on the licensure and the certification for the state and the requirements for your recertification, and that those are only on you. So that's covered in a discussion. So reportable events. In New Mexico, there are certain things that are reportable events. Some of them are crimes, some of them are not. Gunshot wounds, knife wounds, those are reportable. Certain communicable diseases, and sometimes that can change if there's an outbreak of pertussis or whooping cough or something of the sort. That may become a reportable disease for a while. Child or elder abuse, domestic violence, that's actually kind of a sticky one. Domestic violence is not reportable if the victim and the perpetrator are both of age. So if it's a adult male beating up an adult female, it can only be reported if she allows it to be reported. However, if the injuries are obvious, law enforcement can choose to press charges against the abuser on behalf of the state. Even if the person being abused says I don't want to press charges, law enforcement can say it's no longer up to you, and we're going to press charges on behalf of the state or on the county, on the city. Domestic violence is a call that is incredibly dangerous to responders. Generally speaking, domestic violence follows a cycle, and people go through a buildup of tension, and then they have an outburst where somebody is getting abused, and then shortly after the outburst typically follows a honeymoon period where the abuser says, "I'm so sorry." The person who's being abused may or may not to forgive them, and they may actually return to being on good, quote unquote, terms. That's when we will come into the picture, oftentimes, as they're in the honeymoon phase. And they may, as a unit, as two people who just 5 minutes ago were fighting each other, they may turn on you as the outside person, and now you become the enemy. So any hint of domestic violence, you must have law enforcement there. If you get there and it's obvious that it becomes domestic, or it becomes obvious that it is a domestic violence call, law enforcement isn't there, at that point you need to make a judgment call. Do you wait for law enforcement, or do you just get the heck out of there? And I can't tell you every time which one is the right decision. Dog bites are reportable, and sexual assault or rape, sort of the same rules apply for domestic violence. If it is the victim of the assault or of the rape is of age and they don't want it reported, it is not up to you to report it anyway. Now, if the victim is young, if they're old, if they're dependent for some reason, all of that, in cases of both domestic violence and rape, flies out the window, and that's an immediately reportable event that has to be reported to the appropriate authorities. Reporting, and this is an important note, requires actually that you talk to the appropriate authorities. You've got to figure out who they are. So for domestic abuse, if it's a child or an adult, you can call child CYFD, Children, Youth, and Families, or you can call Adult Protective Services, whatever the case may be. But I can't emphasize this enough. Just talking to a nurse or another EMS provider is not reporting it. You've got to report it to the appropriate people. If you don't, you could theoretically face charges. Let's say you go on a call where you suspect a child is being abused, but you forget to report it, and a week later that child turns up dead. You could be in some serious trouble there, not to mention the moral problems you're going to be dealing with, and when you realize that, oh, you could have perhaps stopped this. So just report stuff when appropriate. Crime scenes. When we come to a scene where a crime has occurred, which is a pretty common situation, there are a couple of things you need to think about. Number one is you've got to protect yourself. And that means that if you figure out that a scene is unsafe, you shouldn't be there. So if it is a crime scene, law enforcement should be there first, and they should tell you, yep, scene is secure, come on in. But after that, your priority is patient care. So we're going to talk a little bit about evidence preservation, but your priority is really patient care. That's your first thing. That's what you're there for. So these other things are going to come in as well, but first is patient care above anything else. So when you're looking at the scene, you're doing your windshield or you're doing your walk up to the scene and you're looking around to see what you see, you should be very carefully documenting things that sort of seem out of the ordinary, something that seems unusual. If the patient is deceased, if they're dead when you get there, you should only move them if you absolutely have to. Moving them destroys perhaps evidence, and that may be key to solving a crime. You should not handle everything in the scene. If there's no reason for you to be touching somebody or something, don't. Touch what you need and move what you need only to gain access to the patient. And then if you see knife wounds or a bullet hole in the patient's clothing somewhere, if at all possible, you should be cutting around those things instead of right through them. That preserves the evidence for the people who may end up at some point prosecuting crime. Where you put stuff down can impact, so put things down carefully, trying not to cover up any evidence. If people don't belong in there, they shouldn't be in there. So if it's a crime scene and you're going in to confirm that there's no signs of life or something of the sort, you should only have one, maybe two people in there. And you may at that point need to put your name down with law enforcement, who may be keeping a log of who has come and gone on the scene. And then you should be writing up a report. So you should be writing up what you did, what you saw, and this report needs to be factual, because if you're dealing with a crime scene, the likelihood that you're going to end up being in court on that goes up pretty significantly. So you're going to say, I went to a scene, here is what I saw. You're not going to make judgments on it, you're just going to say, this is what I saw. And what I saw is bop, 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 bop. You're going to lay it all out, very clear and very factual without it. Documentation is a legal record. We talked about documentation in some pretty good detail in another presentation, but it provides a way to evaluate quality of care. It should be clear, it should be precise, it should be accurate, and if you are still handwriting things, it should be legible. So if your cursive writing is illegible to everybody, including your doctor, you need to be working on making sure somebody, a random person, can read that. What are we going to document? Where they were, their issue, what you did for them, their vital signs, who took over, or who did you transfer care to, and if there were any conditions present, those need to be noted as well. Diseases, and anything unusual. So if there's something that sort of makes the hair on the back of your neck stand up, like you see a bruise in the shape of a fist or something of that sort, again, you should document it in a very factual way. So you're not going to say, I think this dad was a jerk who's beating his son. You would say, multiple bruises in various stages of healing. Also, I noted a bruise that appeared to be in the shape of a fist on the patient's left cheek, or whatever the case may be. That is indisputable, factual information, as opposed to if you're writing about the character of the parent, that's your judgment, and that's not what you want to put in there. Some New Mexico specific issues: the EMS Transport Act. This is what allows us to transport against their will. And it has to have 4 parts to it. Perhaps most important for you as EMRs is we need at least an EMT or above there. So they are the ones who have to provide care. In addition to that, the patient must be judged to be in imminent danger of loss of life or limb if they don't get the care they need. They must also be in the provider's good faith judgment, incapable of making a rational decision, and then they must be transported to an appropriate facility. So it would be inappropriate to transport somebody who has a psych issue to a dental clinic, for example. So they've got to go to the place. In New Mexico, we have what are called emancipated minors. So these are young people who have gone through the process of legally getting themselves to be declared adults before they turn 18. Once you turn 18, everybody is considered an adult, but these are people who are younger than that, who for whatever reason have decided that they don't want their parents or their guardian making decisions for them, or maybe they're not alive anymore. Whatever the case may be, they have gone through a process to become what's called an emancipated minor, where they are below the age of consent, but they have paperwork where a court has said, yes, this person can make their own legal decisions. They should have that paperwork with them to show it. It's not enough for them to just say, well, I'm an emancipated minor, you don't need to do anything for me. They have to have the paperwork. Pregnant minors, or minors who are parents, as we sometimes see, they can make decisions for their child. So if it's a pregnant mother, or if it's a father who is below the age of 18, they can make decisions for their child, but technically their parents still get to make decision for them. So being pregnant or having a child does not automatically emancipate somebody. They have to, once they've had their child, if they so choose, they've got to go through that process. The Good Samaritan law, it doesn't protect paid providers. Okay, we talked about that a little bit. It may or may not protect you if you're off duty. That the law has some gray area to it. But if you receive payment from the patient, you are no longer considered a Good Samaritan. You've now been paid, and those protections no longer exist anymore. On the other hand, the patient can make a volunteer provider whole. So let's say you used a roll of Curlex. The patient can, if they like, replace what you used. But if you exceed your scope, if you, as an EMR, say, do an EMT or an AEMT type of treatment, those protections go away very quickly. If the patient pays you, and the pay doesn't have to be in money, if they give you tickets to the opera or to the rodeo or to whatever that have a significant value or really have any value to them, they've been considered to have paid you for the service you provided. Therefore, Good Samaritan protections no longer exist. Okay, so to summarize everything we talked about your duty to act and when that exists, and we talked about the differences, and you need to know these things, the differences between expressed, implied, consent for minors, consent for mentally ill, and the right to refuse care. You need to understand when each of those is applicable and how somebody would invoke any one or the other of those things. Advanced directives, This is paperwork that says somebody wants a specific type of care, or it may be a DNR that says they don't want any care if they should, or they don't want to be resuscitated if they should go into cardiac arrest. And then we talked about abandonment, negligence, confidentiality, and the Good Samaritan laws. There are some reportable events that need to be reported, not necessarily to the nurse you turn over care to, but whoever the appropriate and proper authorities are. And then crime scene operations, basically you should be there and do what you need to do, but you should do your best to ensure that you're not messing up evidence and evidence collections. So, our review here, this is asking you when you have a duty to act, and you can look at those answers, choose what you think is the best one, and we'll look at it here in a minute. Okay, so this says the duty to act exists if you're employed by an agency as EMRs. Again, some ambiguity in the law. Some people have argued that if you are a volunteer, but your volunteer department has a duty roster, and you are on the duty roster to be responding to calls on a certain day, that may give you a duty to act. So you might want to talk to your local chief or whoever the case may be a little bit more about that. Another question, when are patients able to make decisions regarding their care? Again, take a minute, read over the answers, and let's see what you think is the best one. So the answer is if they are of legal age, and the legal age in New Mexico is, again, 18 years old, and the exception to this is if your patient has taken the time to become legally emancipated. So ethical responsibility, what is your ethical responsibility? Look over the answers. And the answer is D. You are expected to conform to professional standards. Okay, that sort of goes without saying. And it should go without saying that that applies to even volunteers. Now, some volunteers will say, I'm not a professional, I'm a volunteer. That doesn't relieve you, being paid or not paid, does not relieve you of the responsibility to act professional. So, if you have any questions, please feel free to ask your instructor, and they will be happy to answer them for you.